land trust legally is a legal entity. So just like an individual, a land trust is a legal entity, and it is a hybrid between a trust and a partnership. It's a hybrid because you use a trust instrument to create it, and you have a partnership relationship between the beneficiaries. The trustee owns legal and equitable title to the real estate, and the beneficiaries hold a personal property interest in the land trust itself. Okay? That was decided by the Supreme Court of Virginia in 1980 in a case that was argued by one of our partners. So it's a pretty cool concept. We have a couple of foundations for a real estate, our Virginia land trust. One is our lovely Code of Virginia. You guys, being in real estate, you've heard of Title 55 of the code, I'm sure. Just maybe a couple of times. And out of all of this, there is one section that refers to a land trust. So statutorily, we have one little section that says that a trust will not fail because of failure to mention the beneficiaries. So that's it for statutory law about land trusts in Virginia. We rely a lot on Indiana land trust, Illinois land trust. We have some case law. We have a statute in Virginia that we have adopted, the Uniform Trust Code, that you think, great, that's going to give me some guidance. And then you go looking through, and about the fourth section of the scope definitions, it says, does not apply to Virginia land trusts. But if you look one section further, it says that a judge may apply the rules and the ideas involved in the Uniform Trust Code in order to help solve a problem where it would be judicially expedient to do that. So the legislature said, it doesn't apply, unless, of course, the judge thinks it would really be in the best interest of everybody to make some of the sections apply. Okay? Instead, we look and we say, all right, what are we going to do? For Virginia Land Trust, we are going to start with a trust document. Two main documents. You have your trust instrument, which creates the trust, and you have your deed in trust, which is what puts the title of the real estate into the trust. All right? Like I said, and I'll probably say it so many times you'll get tired of hearing it, the trustee holds legal and equitable title to the real estate. The beneficiaries hold a personal property interest in the trust. Okay? That's great news, and it's also kind of hard in some instances. You want to create your trust document because you need to set out what the relationship is between parties. It does not have to be expressed. In other words, it does not have to be a written trust agreement, but I wholeheartedly advise that you do a written trust agreement. It is the best practice because you don't want to have to go to something like this to say, what would a default rule maybe be when you get to a problem? It's better off to put it all in writing up front and know and define what your relationships are. The trustee, yet again, holds legal and equitable title to the real estate. So you want to make sure that the trustee is somebody that you trust. Someone who is going to follow your directions. Someone, because the default rule and what is normally contained in your trust instrument says that the trustee has the ability to transfer title, to buy, sell, lease, or otherwise encumber the property. So you want to make sure, since the trustee has that power, that they're doing it in the best interest of the partners, the beneficiaries. So who do you want to be your trustee? Their name is on the land records. In Virginia, we have to include on the deed the address of the trustee. In order to change your trustee, you have to record a new document changing the trustee in the land records. You can't just decide, I don't like you anymore. Most often, there are some businesses out there who are set up specifically to act as trustees on land trusts. Most often, in this area at least, we see either a property management company or an accountant CPA as the trustee. You may see an attorney. I don't act as a trustee just because the type of work that I do as an attorney, there's some potentials for conflict of interest. So I make sure that sell their interest in the land trust. And so you can change beneficiaries without having to change the title on the real estate. So you can then have a decision of either going in and buying partner X's interest in this land trust that owns this or these buildings. Or you can go and buy that building from the trustee. So it's great flexibility. It's a great way to be able to go into business together with you and, I don't know, 10 of your closest friends, want to go buy an office park and don't want anybody to know that you own it, and then want to be able to have the property values go up, the rental rates go up, and you want to be able to sell out your interest.